Good evening. Welcome on in to part 2 of From Day 1. For this episode, let's head right up into the air. Take a look at what we can do in summoning spears and the like. And we will also start our normal sounds and feels of the world, as we do in part 2, with a weird and wild court moment from El Paso, Texas this time. Where, let's just say, there are some folks who try to get one over normally a free-wielding and happy judge. And of course, the epic fails that result. Mike, of course, is along with us since it is a courtroom situation. So that will be the other voice you'll be hearing for this first clip, as we get Dominion underway for this evening.
Yes, now, let's take care of Terrence Matthews, 2017-2251, the state of Texas versus Terrence Matthews, and that's on counsel, please.
Josh Havilah for the state, Your Honor. State ready.
Teresa Cavier on behalf of Mr. Matthews. We're ready, Your Honor.
Betsy Dominguez for adult probation.
Thank you, Ms. Dominguez. Mr. Matthews is not present. I'm not going to waive his presence because there's a bench warrant out, Ms. Caballero.
He's right here, Your Honor, with me.
Good, okay.
He's behind me. You can see.
I do. Good. Okay. Let's talk a little bit about the bench. You want to talk about the bench warrant first? Because the bench
Yes,
warrant
Your Honor. Thank you. Okay. I believe I did file a motion to recall it.
Okay, I didn't know that.
I did, right? Yes, it's been filed.
Very well. Ms. Dominguez, what's the basis of the warrant?
Judge, so we received a call from Ms. Harris, which is the mother of Mr. Matthews' co-defendant, and alleged victim. She claimed that
The mother of the alleged. So her name is Ms. Harris, and then the daughter's name is what?
Brianna Harris.
Okay. So we have a Patricia Harris or a Patty Harris?
Shanique Harris, I believe.
What is it?
I believe it's Shanique.
Shanique is mom, and the daughter is Brianna?
Correct.
Okay, so refer to them by the first names, just for purposes of no confusion.
Okay.
Mike, you want to say something about that?
That makes a lot of sense. I do a lot of hearings, and when you get into something like this where it's involving family, people are saying Ms. Harris, and that could refer to three people important in the situation. So I see where she's coming from.
Thank you, Mike.
Received a call from Shanique Harris. She's a CSO judge. She was covering Mr. Matthews' case while I was out.
Okay.
She claimed that Mr. Matthews had been staying at Brianna Harris's home, and that he was aggressive towards her. He scratched her. So CSO Chavez advised them to call PD, but she did. Shanique Harris stated that Brianna Harris.
Thank you, Jackie. I really appreciate it.
Harris is afraid of Mr. Matthews. So Ms. Chavez asked Shanique Harris to get proof that Brianna was with Mr. Matthews. So as soon as the call ended, Ms. Chavez called Mr. Matthews, who stated that he wasn't home, he was getting an oil change. A few minutes later, Shanique Harris sent a message to CSO Chavez from Brianna Harris, where Shanique Harris asked Brianna Harris, if Mr. Matthews was still with her, to which Brianna Harris stated, "No, I'm with him getting an oil change."
Uh-oh, that can't be good, Mike. That can't be good. Put two and two together. That can't be good.
Shanique Harris didn't know that Ms. Chavez already knew that Mr. Matthews was getting an oil change.
I do.
Thank you, the freshman. We're going through all this. I watched this video. I cannot follow the story other than here's the overarching thing, just so it doesn't get carried away. It's sort of interesting, feel free. But he's harassing a witness. I don't know the underlying fact pattern here. We're kind of in the middle of something that has a lot of history, and I don't know the procedural setup on everything other than he's harassing a witness, and the judge does not like it. And I don't know what the charges are and all that sort of thing, but it's not going well with her.
You recall something in the email, where the mother was very upset. Shanique, you? Shanique?
Thank you,
I believe
Sashay.
that's how you pronounce it.
Okay, Shanique. And for purposes of that's Brianna's mother, but that Shanique was very upset because her daughter has been terrorized by Mr. Matthews, and she was upset that she did not show up for the hearing where we gave her an opportunity to come in, right?
Correct.
Very upset because Brianna has been the subject of Mr. Matthews's ugliness.
Correct.
Threats, whatever, bullying, whatever you want to call it. So I remember that in the email. Okay. Now,
Cats.
Miss Caballero, the problem is I've had so many problems with Mr. Matthews. This isn't the first time. This is the third or the fourth. Well, I've had issues on PR bond and revoked, and issues on PR bond and revoked. So I guess at this point, I know, Miss Caballero, you asked for that text. I didn't. I was going to send it to you, and then I had a discussion with Mr. Avila about it, and I had forgotten that Mr. Avila hadn't even gotten it yet. So I said, just get Miss Caballero on, and we'll discuss it. And so at this point, I think there's no problem if you don't have it on your computer to share the screen, right, Miss Dominguez?
Thank you, Big Wave
I
Dave.
do, Judge. I do for it.
Your Honor,
Yeah,
of
she
course
did.
I want to see it, but even if I see it, it's double hearsay.
That's interesting. So the attorney here, and this attorney is very good. Here's the defense attorney, the woman in front here. The defendant is the guy in the mask. And she says it's double hearsay. And hearsay is an out-of-court statement offered to prove the truth of the matter asserted. What they're describing is a text. And what they're trying to establish is a probation or parole violation, because I'm guessing that he has a stay-away order.
Probably.
I actually don't know that stuff, but you'll see going forward. That's the construction that I make out of this situation. So she says it's double hearsay. Well, this gets very technical, and here's why you need an attorney. That's going to work fine at a hearing, but he's got a bench warrant out right now. She can send him to jail. Simple as that. I don't know if she's doing it off the warrant or if she's sort of sua sponte revoking his bail for harassing a witness. I literally haven't figured that out. Either way, it doesn't matter. The judge is not happy with this defendant.
And I think what I would ask the court to do, and I understand the court's trepidation with this, but I think we need to have a hearing with the witnesses.
Well,
Because
but I'm not going to recall the warrant.
So what that is I think we need to have a hearing with the witnesses, and I don't know, again, the factual underlying basis of this, but what I'm thinking is this is essentially a domestic situation, and they're not getting cooperation from the witnesses.
You have
And
that
the
right.
defense
Mike.
attorney's doing good things, saying, well, yeah, you can kind of hold him for a little while, but you're not going to be able to sustain that because you're not going to get cooperation from the complaining witnesses against him on these violations. And it's a good sort of legal tactic. I get why she's doing it. There's nothing wrong with it, but the judge is irritated by it, rightfully so, because she's just sick of this guy doing these things.
Because I have what I need, and he needs to turn himself in. I will have a hearing. Yes, ma'am. You ask for a hearing, I will have a hearing, and we will tell mother she needs to show up. At least mother. If that's not enough, I mean, if she has not seen specifics and witnessed it firsthand, Ms. Caballero's not going to let it in. I know that.
But
So-
we know from what Ms. Dominguez just said that the mother did not see anything.
Well, mother maybe has seen it throughout this whole time.
Well, to what Ms. Dominguez just read, just to put it into perspective, Your Honor, the mother calls the active duty officer and says that my client is at her daughter's house. Presumably, Brianna must have called her mother, if you're to believe that. Brianna calls the mother and says, Terrence is here. And the mother calls probation and says, Terrence is at my daughter's house. But according to what was just read, mother never saw it.
No, but there's a text that says...
Thank you, Mickey the Bull.
There's a text that says, are you still with Mr. Matthews? And Brianna answers, yes, I'm here with Mr. Matthews getting an oil change.
This is just fascinating to watch, and you can see these things are kind of hard to prove up. This guy's harassing the witness and saying don't talk and do things and was aggressive with her, and the judge is irritated. The attorney is doing hyper-technical things like citing hearsay and saying you're not going to have witness availability and all that stuff. She's right. And that's the little fight we're having. It's very respectful. The judge likes this attorney and has respect for it. It's clear to me. And the attorney is smart, the defense attorney. But she's like, I don't care. I'm finding a way. This guy is not behaving right, and I've had enough. She has a history of it, as you'll see as we go.
So we have, okay, maybe I didn't follow that thread. So you're saying, or Ms. Dominguez is saying, that there's a text from Brianna's telephone verified.
Right, I think so. I think I remember seeing that, yes. And I verified all.
Okay.
And I verified that it was Brianna's number and all of that, yes.
How do we know that's Brianna's number?
Miss Dominguez, can you answer that? I don't remember.
Oh, this is fantastic. So she's got a text, and that's her basis. She's saying, look, yeah, the problem is I've got all this verified by a text, and the attorney's like, yeah, well, it's double hearsay, you're going to have problems, no one will testify, all these sort of technical things. And this is where we get into it. It reminds me a lot of the video I did with Judge Simpson, where a guy sent a bunch of nasty texts, and he was supposed to pay child support. He sent a bunch of stupid texts, and the judge was like, you're telling me you didn't send those? We're having that again. And she's doing real technical defenses. We know he sent the texts. But she's saying you're going to have a hard time proving, which is true. Although she doesn't have to prove it, the prosecutors do. But she's like, I've got enough to pull him in on off the bench warrant or to revoke his prior bond, and I'm doing that for now. But to keep him there, she's going to need some cooperation or some proof from the prosecutor, and that's where we are here. So she says we don't even know if that number's the right thing, and you'll see that's what I find really interesting here.
I would have to ask Ms. Chavez, Judge. I was not there. But I do have the number I can call to see if that's her, see if she answers.
Okay, call right now.
Call right now. I like the judge. Yeah, call right now.
On the record, I want you to say, hello, Brianna. Who is this? And I want to hear Brianna. And it's the same number that's on the text, right?
Correct.
Oh.
Yes, Judge.
Thank you, Your Honor.
I like that. Hi, Brianna.
Abelard is doing Caballero's trick, and he is signing in twice on 2 devices. We have Mr. Rick. We have 1+ Nord again. Okay, go ahead. I'll be quiet because we have to pay attention. Go ahead, Ms. Dominguez. Let me back up. Ms. Dominguez was on medical.
How am I to speak to Brianna Harris? This Hi, Ms. Harris. This is Ms. Dominguez. I'm Terrence Matthews, probation officer. Okay. Judge Ron Hill.
Wah, wah, wah. So the attorney's like, we don't even know if that number is correct, which is a good thing for the attorney to say. I mean, it's true. It's like you haven't even verified it. And judge said, go ahead, call it. And she gets the person on the phone. That's a pretty good verification in court with everything going on. But here's where it gets interesting.
We're in court with Judge Ron Hill, and she asked me to call you. Okay. And it's her judge.
Okay, it's Miss Brianna.
Thank you, 36th District Court.
Miss Brianna?
Yeah.
Well, okay. Nothing. Thank you so much. I appreciate her. Thank you, I appreciate her.
Thank you, Your Honor.
This is the problem. This is the problem. If I ask her any questions, this man is going to go back and retaliate. That's what he's going to do. So I didn't want to put her in any position at all.
Uh-oh, Judge.
Because I know what you're going to do, Mr. Matthews. You need to turn yourself into jail right now. And I'm fed up. And you're going to stay in jail until your case is tried, or until you plead guilty, or until we can impanel a jury. Or I don't care how long, but this is the fourth or fifth time that I've gotten a report about you, and I believe them now. And if you go back and you terrorize Miss Harris, because Miss Harris didn't do anything. All she did was answer her phone.
Miss Rangel.
I'm not Miss Rangel.
Judge Rangel.
No.
That's right.
Don't drop a Miss Rangel on a judge in the middle of that rant. Just a thought.
Try, Miss Caballero. You know me.
Thank you, Your Honor. And well, also, Judge, I think she's a co-defendant, and it would be inappropriate for the court to question her.
Oh, I forgot that part.
Yeah,
I forgot that part. I was more worried about her safety, that he was going to go back and retaliate because she admitted something to me. That's why I had to think twice before I put her in that position.
Okay, Your Honor, I'm going to advise my client to turn himself in.
Yeah.
And we'll set this for a hearing.
Very well.
Thank you, Your Honor.
What's the offer, Mr. Let's try and do this as a settlement conference. What is the offer, Mr.?
But so this is a probation case, right? And I believe one of the violations was that he picked up a new case, among other things.
Be revoked. Can we do that? Say that for a revocation hearing in person?
Well, Judge, we don't have a motion yet. We haven't gotten the VN.
I don't care, but he's giving me too many problems already on probation.
Right, Judge. You just need to authorize.
I don't know what it is. I'm guessing he says we don't have a VN. I'm just like absolutely speculating, but I would guess that would mean a violation notification or something like that. She's saying I want to revoke this guy, but it's not.
It's like your Illinois revocations, Mike.
She can send him to jail because he's got a warrant and she has reason to believe that he's in violation of his bond. So she certainly has that, but she wants to get to him longer than that. She is tired of it. She's expressing that to the prosecutor, but the prosecutor is the one who really has to do it. The prosecutor's on board. He's like, yeah, they're in violation, but it hasn't gone through the works yet, so we can do this. Some people might look at this and say, oh, she's acting like a prosecutor. No, she's not. She's acting like a neutral judge. What she has is she's decided after a long time on this case and the information that she's developed that this guy should not be out anymore. That's not taking sides. That's coming to a conclusion after seeing a lot. That's a very appropriate thing for a judge to do. But I'm just going to head that off at the pass because I know I'll see it in the comments. The judge is supposed to be neutral in the sense that they take in the information and do what they think it makes sense. But when you take in the information, that might nudge you one way or the other on how you proceed going forward. That's your job.
A VN so I can get a history of his violations since the last time a motion was filed.
Give me a history, Miss Dominguez. You know better than anybody. What's the history of his violations on probation? Wait, what's the offense? He's on for a what grade offense? First, second, or third degree?
It is a second degree, Judge.
And what is the new offense?
The new offense.
First, second, or third degree?
Sorry, Judge, the new Odyssey is really slow.
Your Honor, I don't recall, and I don't have the file right in front of me when you see, but I do think that the state has problems proving the new offense, and that's the evidence is tenuous, and that's one of the reasons why you gave him.
Well, everything is technical, and she does not like this. She's not mad at her. These are all appropriate defense arguments, but you roll with what you have. The defense attorney here is very, and her guy's doing bad stuff. She has no doubt about it. The judge is cranky about it. And all the defense attorney can do is say, we haven't proved it yet. And there would be problems proving it. And to that extent, she is correct. But the judge does not like hearing it, and I don't blame her. And by the way, thank you, Andrew. I deserve a naughty adventure. I don't know, but I like it.
A bond on you let him out because of the tenuous facts.
Actually, wasn't this case referred to a bond to some other court? I think.
Right. It was Judge Garcia.
Judge Garcia gave him a bond.
Judge, we had a knockdown drag out in front of you. Don't you remember?
That was before. And then I was absent and Judge let him out.
Judge, the new case is also a second degree.
Oh, good. Let's do a revocation. Let's put this on the revo track. I'm going to put this on the revo track. I didn't let him out, Miss Caballero. Judge Garcia did.
Okay.
Judge Garcia let him out.
We had a hearing, Your Honor, where you, I guess, stayed with it. He's had so much non-compliant behavior. I did let him out one time, but this last time, Judge Garcia heard. Okay. Did he sign the bond hearing, the bond, or did I, Mr. Sam? The last bond hearing.
It was him, Judge, but I don't recall if you.
Did I sign it or did he sign it?
I'm looking at you.
I signed it?
Yes, Judge. I think what happened was Judge Garcia had implemented his own bond, and then you went back and then imposed your own conditions on it again.
Oh, that's what I did. Yeah, because he didn't include some of the stuff, but I still kept him out, though.
Okay, so she apparently was out for a little bit. I'm just gathering this from what she's saying.
Yes, Mike.
So she had let this guy out before and gave him a chance, and
the guy fucked up.
And she's saying, I've had enough of this stuff. But while she was out, another judge let him go, and she just went back and imposed some additional conditions on that judge's bond. But she didn't really let him out the last time. So it's very intricate, but that's what's going on between her and the defense attorney right now.
Yeah, we had a long hearing, Your Honor, and it was revisited.
Okay.
And you allowed him to stay out. Anyway, I will inform him that he knows to turn himself in. You told him. And then we will set this for a hearing. And then we'll go from there.
Yes, ma'am.
Thank you, Your Honor. Thank you very much.
Thank you.
Bye-bye.
What am I setting this for right now currently?
I think it would have to be a pre-revo.
Set it for a pre-revo first, and then we'll set it for a contest.
How far out, Judge?
Because we're doing this on the pre-revo track now. Okay? So I'll explain that to you a little bit.
No.
I don't understand.
How far out, Judge? How many days, weeks?
Another pre-revo. Let's do another pre-revo in about 3 weeks. 3 weeks to pre-revo. Thank you. Thank you, Ms. Caballero. Mr. Matthews, if you know what's good for you, you got to turn yourself in. You don't do.
There she said it. Thank you, by the way. You know, it's a good thing I got that in this case. I get this question so much.
Mike, we don't need to hear about your puppies. Yes, they're cute. Yes, they're awesome for you. But Mike, when we're doing a dual stream, we don't need to talk about puppies. Okay? Alright, come on, Razul.
Motion to revoke is not filed. I will be asking for him to be released.
Okay. We're going to do VN. Ms. Dominguez, you're going to do VN, and Mr. Avila, you're going to do a motion to revoke.
Yes.
That was an odd exchange to me. She said if there's she wants a petition to revoke. The prosecutor's going to do it. He's on board. This guy's doing bad stuff, so he'll file this stuff. He already knows the judge is favorable to it, assuming she has the evidentiary basis. That's all she's waiting for, because she's had enough of this guy. I don't know why the defense attorney did that, because it's almost bad. Like, why would you say prospectively, I'm going to ask to let him out in 3 weeks when we come back in the pre-revo? Because what that effectively does is remind her and the prosecutor to get their lives together. Not that they don't know, but it's like extra thing. It's like saying, hey, make sure you have your stuff together so my client doesn't get out. because if you don't have a factual basis to keep them, I'm going to be asking to pop them. I don't know why she did that. I strategically don't know why she did that, but I don't do criminal defense.
Turner.
Whenever he's on. Yeah. Yep. He's going to go through. Thank you. You may be excused. Thank you.
Bye-bye.
Are you excused, Judge?
Yes, ma'am. Thank you, Ms. Dominguez.
Alright, so that works for that. These guys try to continue to take down Nos, the Doom Herald. They're not having a great time of it here, 35 seconds in. So, well, that's going. Then we find ourselves another. Well, they got it at least under 50%. And there you go. Winner, winner, chicken dinner. Alright, so what happens when you take a sovereign citizen, throw him in court, and add a little bit more on top? Well, you get tonight's individual, Anthony Williams. Let's go to court and hear his bullshit. Anthony?
And here we go.
Thank you, Mike.
Using on the special calendar, SP 13-10470, the matter of actions for Anthony Troy Williams of Fair Disputes.
Good morning, Honor. Senor Mariano, Deputy Attorney General for the State of Florida.
Good morning, Honor. Deputy Public Defender Catherine Gutierrez. Your Honor, making a special appearance, and Your Honor, Mr. Anthony Williams is present.
Good morning. Are you ready to proceed?
Well, Your Honor, I do believe the state has some representations as well as myself.
Your Honor, I guess with regards to the hearing, I guess at this point the state doesn't know what the defendant is going to do at this point. So until that is said, then the state has nothing right now.
Okay.
Your Honor, I spoke to this gentleman next to me who indicated that he doesn't want to represent himself, as I did indicate to the court earlier, and I think he wants to go on the record with respect to that.
Is that right?
That's correct.
You don't have to talk more. I just talk to you. It's all in record.
Private Attorney General Anthony Williams, as codified in Title 42, USC 1988.
No, you're not. Shut up.
These charges against me are...
Oh, there we have it. I'm Private Attorney General. I've heard so much about this, but I just ran across it recently. And it is, well, it's just as deliciously awful as I anticipated.
False. My understanding, I haven't been able to see the paperwork. I really wanted to look over them to see what the state has as far as even to have a lawful warrant, Fourth Amendment warrant to get me, which they had to have probable cause, which I know they didn't, because I was here in Hawaii on the alleged crime that they're saying that I committed, which my son was also a defendant, and it was dismissed on August 22nd of last month. The defendant that they're charging, all capital letters, Anthony Troy Williams, is actually a corporate fiction, a legal person. And that's
Here we
not
go with
me.
the
I do
sovereign
not
citizen
have a
bullshit.
Social Security number. I'm actually a foreign diplomat, and I'm a U.S. non-citizen national or an American. Therefore, the court...
Wow, that's bold. He's a foreign diplomat, he says. This is all, of course, crazy. He's just launched into the substance of it. The question before us is, who's going to represent you? Stop with the defense of the case. The fact that you're giving a defense of the case in response to that question shows that you have no idea what you're doing and need someone to represent you.
Correct.
Does not have jurisdiction. The state of Georgia never had jurisdiction. Also, they haven't even proven my identity who I am. So today I move the court to dismiss this with prejudice.
Okay. First of all, Mr. Williams, do you understand why you're here?
I don't understand why I'm here.
Okay.
What I was told is that it's an extradition hearing.
Yes.
From the state of Georgia on a false warrant that was issued. That was also issued against my son, which has been dismissed also.
Okay. There has been a complaint filed in this court indicating that you stand charged in the courts of the state of Georgia with the felony section 16-4-4 of the state of Georgia Penal Code, a crime punishable by imprisonment for a term exceeding 1 year. That's a complaint. Whether it's true or not is not really an issue here today. So Georgia has demanded that this state make you available for transport back to Georgia to answer the charge. Now, you have a right to demand or procure legal counsel. You have a right to an attorney to represent you at these proceedings. Now, Ms. Gutierrez has indicated that you want to represent yourself. Is that true?
In propria persona, yes, sir.
Okay. Then I need to go through a little bit of a question and answer session to make sure you understand your right, just for the record.
I guess this attorney is the standby counsel.
Correct.
That's all I can think of. They want to appoint her, but he won't accept it.
That you understand your right to counsel and that you are knowingly, intelligently, and voluntarily waiving it. And then if you can indicate that about to represent yourself through the remainder of these proceedings.
And after those questions, can I question? I need a few questions I need to ask the court also.
Okay.
On and for the record.
Okay. Mr. Williams, how old are you?
Right now, should be 42.
How much education do you have?
I have more education than the most trained lawyer you can find.
Bullshit. Oh, did I say that? Hold on, let me fix it. Bullshit. Oh, see? There it goes again.
I'm skeptical.
Yeah, I agree.
So, do you have any problem reading, writing, or understanding English?
No,
Yes.
Are you under the influence of any alcohol or drugs today?
Yes, he
I've
is.
done drugs in my life.
Are you under treatment? Excuse me. Are you under treatment for any mental illness or emotional problem?
No, I'm not.
Is your mind clear?
Very
No.
clear.
Now, do you understand that you have the right to be represented by a lawyer in your case? And if you can't afford a lawyer, the court will provide an attorney to represent you for free.
I have to ask you a question on that. When you say lawyer, do you mean a counsel of my choice, or are you restricting that counsel to an attorney at law that has a certificate of admission to a monopoly called Bar Association?
B. We're gonna
B.
go with B.
I was gonna say, I agree with you, Mike. B.
You can hire anybody you want if you can afford to pay that person. And if you cannot, then the court will appoint a lawyer licensed by the Hawaii Supreme Court.
So, but that person does not have to be a person that's a part of the bar that I hired.
In order to practice law in Hawaii, you have to be a member of the bar. Okay. So, you can't hire a non-lawyer to represent you. You can represent yourself, but if you have someone represent you in the courtroom, then it has to be a lawyer who's passed the bar.
But then that would be in violation of the Supreme Court rulings, NAACP versus Button,
No, it isn't. But okay, carry on.
Schwell versus Board Examiner, Frankenhauer versus Rizzo, and also Aaron versus Sims, which specifically states that non-lawyers or people that are competent can represent others in court without being charged with the charge of unauthorized practice of law. Also, Federal Rules of Civil Procedure 17 U.S.C. 28, I can hire someone as a next friend to represent me if I so choose without having to use an attorney at law.
Okay. But you understand what I just told you. your objection, if that is an objection, is on the record. If you hire a lawyer, it's got to be someone who is licensed here in Hawaii or is otherwise authorized to practice here in Hawaii. And if you can't afford someone and you want me to appoint someone to represent you without charge, then it's going to be somebody like the public defender, Ms. Gutierrez, who is in court here. She's passed the bar and he's licensed.
Can I have anyone that would be a lawyer produce a law license for me to inspect before I even consider them? Because I still have yet to see any lawyer's license that says they have a law license. I have yet to see one. I've asked plenty of attorneys and they don't have a law license. They have a certificate of admission, which is not a license. I also called the Department of Professional Licensing and Vocational Division, and they say they don't have any attorneys at law licenses in their office, that's the office for all professional licenses. So I'm still trying to figure out what license do a attorney at law has that would constitute a valid law license according to the state and federal law and according to the Constitution.
It's real easy. If you're in the role of practicing attorneys in that jurisdiction, that's it. There's quite literally a list maintained by the licensing authority, and that means you're licensed, and you have to pass the bar and meet certain requirements in order to get that. All this is complete nonsense, of course. It is kind of funny. I see this through the prism. I did a big thing on the Marrakesh Law Society. I'll put a link to that in the description.
Oh, those losers.
But this precedes that, and I think that they may have drawn some inspiration from the private attorney general here.
If you want a lawyer and you can't afford to pay that lawyer, your lawyer will be Ms. Gutierrez. And the court is aware that she has passed the bar and is licensed to practice law in Hawaii. She's a public defender, as appeared before me for many years. And she will be your lawyer. You may have a position or an objection to that. You can state it if you want to, but...
I do. I represent myself.
All right.
Well, you're doing great so far with that license argument.
Yeah, he's 0 for 1.
Okay. This is important. Do you understand that if you represent yourself without a lawyer, the judge cannot and will not help you, and that you will be required to follow all of the technical rules and the substantive, procedural, and evidentiary law applicable to your case?
No, that's incorrect. My understanding is that the law states that non-lawyers, people who represent themselves, are not held to the same strict and stringent laws as attorney at law, and their pleadings cannot be judged as such.
This is actually interesting, and believe it or not, I think he's right. In a sense, I think both of them are right. The stated rule is if you represent yourself, you're held to the same standard. But in practice, that is not the case. Pro se litigants are given deference. There's no two ways about it. It's if you live through it, if you see it, and I've seen it, not myself because I'm an attorney, but I've seen pro se litigants get called in a case before me, so I have to watch that go out. A lot of times the judge will ask for a volunteer because the courtroom will be full of attorneys to draft an order because they don't know what they're doing. They will continuously ask for assistance or just be so far off the path that the judge can't help but put them back on the path and help them a little bit. They hate it. They're cognizant of it. They don't like doing it, but that's what happens when people represent themselves. So it's kind of interesting. The judge was correct, and that is the stated rule, and he was advising of that. But the practicality is exactly what this guy said. He is correct.
You and I disagree, but you understand what I've told you.
I don't understand none of that, sir.
Okay. What is it you don't understand about me telling you that if you represent yourself without a lawyer, the judge cannot and will not help you, and that you will be required to follow all of the technical rules and the substantive, procedural, and evidentiary law applicable to your case?
Well, sir, the reason why I don't stand under that or understand that is because you are supposed to be under an oath to uphold the Constitution of the United States of America. which you're supposed to guard against anyone trying to infringe on my rights as an American citizen. So,
and also the rights of the other party. The judge is neutral. Goofball. If you're an attorney, you'd know that.
if you're not on that oath, I need you to state that for the record today. If you're not on your oath, but if you are, then I do expect for you to protect and guard all my constitutional, divine, and common law rights.
I'll try my best to do that.
So are you on your oath today, sir?
I'll try my best to.
Your Honor, do you want to kill him?
Right.
Well, I'm saying, well, are you on your oath today? Or is your oath up to date and current?
Dude, at this point, most
uphold the Constitution for the United States.
lawyers would have got themselves
I
arrested.
took it off and I was sworn in as a judge.
I understand, sir, but is that on file? It's on record right now.
Okay, so this is this is a perfect illustration of what we were just talking about. He is, we're not there yet, we're just talking about it, but if he's representing himself, what he just did to the judge is straight up contempt of court if an attorney tries
Thank
that.
you.
An attorney knows better, and if they said something like this, they would be warned. I mean, not immediately, but if you continued down this line, you'd end up in contempt of court. The only reason why he's not there right now is because the judge is giving him deference because he's representing himself in the moment.
Got me, but I did
I'm
take
saying,
it
sir,
off.
but I'm saying in order to, adjudicate in front of me and to be lawful, you have to have that oath of office, current, and I can, by law, I can demand it be entered in on the record to make sure that you will guard my constitutional rights as you are sworn to, or supposed to have sworn to an oath to do, sir.
Your Honor, you do have the rights to
We're
totally
all
kill him.
sworn in when we pass the bar and get licensed. We all have a big swearing-in ceremony. We raise our hand and we swear to uphold the Constitution of the United States and the Constitution of the state that we are in. We have certificates of our license, and a lot of us have them hanging on our wall. I have it hanging in my office. But there's nothing beyond that. There isn't a transcript of the swearing-in ceremony, or there isn't some notarized. They love a good notary. There isn't a notarized document. That's it. It's implicit in the fact that you have a license, that you were sworn in at some point, because that's something you have to do to get it.
I understand what you're saying, but
So we're in agreement. Are you on your oath today?
no, I've indicated that I understand what you're saying, but whether I agree with it or not.
Which you don't.
Is not an issue right now, as far as I'm concerned. But your position is on the record. Okay?
I'm still not understanding, sir, but that's mandatory for you to be on your oath of office. When you sit on the bench, so to make sure that I don't get railroaded by the prosecutor, to make sure that these proceedings are fair and that they are constitutional. I mean, I just asked a simple question, sir. Are you on your oath today, and are you going to uphold your oath to the United States of America, Constitution of the United States of
Your
America?
Honor, just arrest him.
I'm going to do my job to the best of my ability. Let it rest there. The next question is, do you understand that acting as your own lawyer could substantially hurt your chances of obtaining a favorable result in this case?
No, I do not understand that, because in the interest of justice, it shouldn't matter whether I have an attorney at law or not. What should matter is the truth of the facts of the case. And the truth of the facts in this case is that the state of Georgia do not have a viable description of me. I wasn't the person that they're talking about. I'm a separate entity than the entity that they charged. And the incident that they're saying, they didn't have probable cause because I was here in the state of Hawaii in the incident that they're charging me with.
Okay, the allegations in Georgia are not for me to determine one way or the other. The issues in an extradition proceeding are limited. Guilt or innocence is not one.
Can you state those issues for me, sir? What are the issues?
I can't help you. I can't tell you what to do.
No, I'm not.
That's why you have a lawyer. If you want a lawyer, Ms. Gutierrez is standing right next to you. If you want to represent yourself, I'm not going to help you.
No, sir, I'm asking you what are the issues, because you said those issues that I brought up aren't the issues. So by law, you have to tell me what the issues in the extradition that I'm being charged with.
I don't think he does.
He did, and you weren't paying attention, and he doesn't need to tell you again. He might, I'm not sure.
I read the complaint to you. The state of Georgia has alleged that you committed a crime in Georgia, and they want you back there to answer that. That's what this extradition proceeding is all about. Now, what you and I are talking about at this moment, though, is whether or not you want a lawyer to represent you or you want to represent yourself. And I'm required to advise you that representing yourself could be detrimental.
No.
You can understand that.
No, I don't understand that, because the reason why I can't understand that, sir, is because every
Because
time
he's
I
an idiot, Your
represented
Honor.
myself, I've always won. Every time I had an attorney at law represent me, or anybody that I know, they've always lost. So my chances are better with me representing myself, understanding my constitutional rights, common law rights, and divine rights and human rights, than to rely on an attorney at law who is an officer of the court, which you are also an officer of the court, and both of you are part of the same organization, which creates a conflict of interest. The reason why this proceedings cannot go further, because the jurisdiction has been directly challenged. The state of Georgia doesn't have any jurisdiction. The state of Hawaii don't have any jurisdiction. I've already have the paperwork filed that I'm not a U.S. citizen. I am an American national. I am a foreign diplomat with sovereign immunity that's already been established on the record, sir.
Oh, Lord.
Do you understand that if you disrupt the trial...
Oh, he's disrupting the trial. How nicely that happened.
Well, there you have.
I say nicely, he decides to disrupt the trial. Yeah, that would be good. I like the other. If he decided to disrupt the trial, and boom, guess what? He disrupts the trial. I love that one. Disrupts the trial. And finally, just because I like to be fair, what happens when when lawyers are in trouble? Well, we have that in today's final courtroom appearance. For that, we go to one of my favorite states, the state of Hawaii. The state of Nevada, Las Vegas to be precise. And here.
That this hearing is taking place outside the presence of the jury panel. Defendant is here. He's in custody. Mr. Karamingo, I want to address you first because it's my understanding you might have some problems this morning.
Judge, I was heading east on Sahara Drive and I was rear-ended and my car was undrivable. A good Samaritan drove me to the courthouse.
Who? Just someone picked you up and drove you here?
A good Samaritan, who's a Las Vegas local, drove me to the courthouse. And his name is Chris.
Don't worry about it, Judge. I got a ride from Chris.
And I apologize, Your Honor. I left my house at 9 o'clock this morning. And I was rear-ended. The person who hit me took off. And
Hit and run?
It was a hit and run, Your Honor.
You called the police, obviously.
I did not, Your Honor. I'm not in favor of dialing 911.
Especially not when I've been drinking and driving.
Please stop giving away the secret.
Even when you're the victim of a hit and run?
Philosophically, Judge, I never called the police.
Because?
My car is on Rancho west of Sahara with the flashers on, with much body damage. It's a 2006 Audi. And here I am. And I asked my office to call the court to let them know it's going to be late.
No, we did get that phone call.
I apologize, Your Honor.
I'm just a little concerned.
Man, is this judge nice. She's got a sweet voice, but she is not buying any of this.
So your car is just there on Rancho, west of Sahara, in a lane? Did you pull?
It's in a turning lane, Judge. Someone was kind enough to pull up and push me into the turning lane, and it's there as we speak.
And the person that rear-ended you went around you and took off.
Yes, ma'am.
No license, nothing?
I didn't get it, Your Honor.
And,
It's a pretty hard hit, and
right, because you don't look, I'm going to tell you, to be honest with you, you don't look right this morning.
No, that's an understatement.
Good call, Your Honor.
Judge, my neck and my back is killing me. But I'm ready to go forward.
No, you're not. Your Honor, no, he's not.
You don't think you need medical attention?
I think I do. I think I do, Your Honor. But
Okay, well, how about I have the courthouse nurse at least come up and take a look at you?
I'm going to go ahead and decline that for the same reason I didn't call 911.
Ah, yeah.
Judge,
You a fan of
I'm
that?
willing to play hurt.
Pardon?
I'm willing to play hurt.
Willing to play hurt.
Well, the only problem with that is that sometimes that creates problems in trials.
I understand.
I'm not willing to play hurt. I want to be 100%, because that's not
I
fair to
do as
you.
well, Judge.
And it's not fair to your client if you're not 100%. And I'm telling you my observations of you are,
I may have suffered a concussion, Your Honor.
then for sure. Do you think you hit your head?
Judge, I know I had a serious whiplash, and the driver that hit me took off. But I feel like I'm able to go forward.
You feel like you suffered a concussion
Yes, Your Honor.
because you hit your head?
Just because of the whiplash, Your Honor. I've had multiple concussions.
Now whiplash.
And I feel like I may have suffered another concussion.
You've had multiple concussions.
Yes, Your Honor. I played professional ice hockey and I also played college football.
Okay, so you know what it feels like.
Yeah, my head has been the subject of many severe contacts.
Yeah, that's putting it mildly.
But I feel like I can go forward.
Okay, well, you just made a real great record for ineffective
No,
assistance at
Your Honor, I don't mean to make.
You know what? Can I just see everybody back in chambers?
Oh, was that just the most awkward court appearance I've ever seen? And it's funny because I'm operating on the presumption that he's just trying to cover up for the fact that he was drunk, and therefore is digging himself a deeper hole. I hope he doesn't have any deeper issue than that.
He does.
He does have traumatic brain injury or something like that. I just don't suspect that is the case. The other thing that kind of struck me is the judge was such a pro. She was.
That's correct. And Mike, I'll have to I have to leave you for today. I'll have to get you in future times that we're together. That there is a lot more to unpack. The nurse comes up. The nurse assumes the alcohol. They actually get a officer up to actually do a blood alcohol test. Breathalyzer, that is. It really gets an interesting situation. So actually, people always say that I'm always touching U.S. and not anything outside. So, with my good friend the barrister, let's go ahead and touch on a little UK. Please pull over.
For pulling me over, you need probable cause. Because in the United States, police officers need what they call probable cause, which is our equivalent of reasonable grounds for suspicion, which is unbiased before they can pull over a vehicle. And many of you, with great respect, will mistakenly think that that applies in the United Kingdom as well. But that is not quite the case. And that's what I'm talking about today. But if you're new to me and my channel, I'm a barrister who helps you understand law. So please hit that subscribe button and the bell icon so you get notifications of new videos. And you can also join me for live streams on Sunday at 10 a.m.
Okay, I said enough of the plug.
And answer your questions in the comments.
Yes, enough of the plug. Let's get to the actual case.
Me directly.
I said the actual case, Mr. Barrister. I know you're an attorney. You love to get your plugs in. There we go.
Section 163 of the Road Traffic Act 1988 provides police officers the power to stop any vehicle without any particular reason, and the wording of this section of the Act is very clear. Section 163 provides that a person driving a mechanically propelled vehicle on a road must stop the vehicle on being required to do so by a constable in uniform or a traffic officer. A traffic officer may include one of those cars you see going up and down the motorway. They may look very much like police, but they are designated traffic officers, and the same powers apply. And the same is true for cycles as well. Subsection 2 provides that a person riding a cycle on a road must stop the cycle on being required to do so by a constable in uniform or a traffic officer. And under subsection 3, if you fail to comply with such a request, you will be guilty of an offence. So this kind of stop is typically known as being pulled over. You can be pulled over by a police car flashing blue lights at you. You can be pulled over by a police officer waving you down, standing in uniform in the street. At various times of the year, typically at Christmas and New Year, there are usually various campaigns, such as drink drive campaigns, where they are pulling over vehicles to speak to the driver, where there'll be a designated area that police officers pull cars over for the purposes of speaking to the driver to try to ascertain whether or not the driver has been drinking. If the officer forms the reasonable suspicion that the driver is under the influence of drink, then there could be more serious consequences. Other instances may be referred to as a stop check. This is where police officers are simply pulling over random vehicles to check the overall safety of the vehicle,
there you go.
such as the tyres,
We're losing connection with you.
lights, and so on. If the officer were to find something wrong with your vehicle, such as a bald tyre, you may well be given a fixed penalty. Or for something more minor, you may be given what's known as a VDRS, which is the Vehicle Defect Rectification Scheme. In other words, if there is something minor wrong with your car, such as a cracked light, or one of the lights isn't working, or one of the indicators isn't working, or something
Come on.
of this nature, the police officer may not think that it's serious enough to give you a fixed penalty by way of a fine and perhaps points, and instead give you the correct.
Basically, saying it's going to they'd give you the equivalent of what we in the U.S. call a fix-it ticket, where it's basically, hey, this was spotted, correct it, type situation.
And then go to the police station within 14 days with evidence that this has
Except the UK, it's got a little more teeth because they actually require you to prove that you fixed it.
been corrected. This is usually done by going to a garage, and the garage can sign or give you something to prove that you've had the work done. Then you take this VDRS slip to a police station to prove that you've had the work done. But that's not the
Sorry, Burst, I'm trying to fix our connection with you.
full extent of what might happen if a police officer pulls your vehicle over to the side of the road. One thing that is similar to the United States, and ironically something that I've heard many people say is not the case in the UK, is that police officers can require you to produce your driving license, and in some instances your date of birth, and failure to provide either your driving license or your date of birth also amounts to an offence, although there is a defence to failing to provide your driving licence there and then, if you do so within 7 days. This is usually by taking it to a police station and often referred to as a producer, and the power to require drivers to produce their driving licence and date of birth is found in section 164 of the Road Traffic Act 1988. And as you might have guessed, this is not limited to the driving licence, it also extends to insurance information, which is in section 165. And again, failure to provide evidence of your insurance will amount to an offence, but again there is a defence under subsection 4 that if you provide this within 7 days, you shall not be convicted of failure to provide your insurance information. Section 165 also requires the driver to provide the name and address of the owner of the vehicle. And of course it goes without saying that if you do not have a valid driving licence and or you do not have valid insurance,
I apologize, guys. We're just having trouble keeping the connection with the UK for this barrister. My apologies. I honestly do not know why we're having that trouble tonight. I think I might have him back. Let's try this again here. Barrister, are you there? Barrister? Going once. Barrister going twice. Unlike Southern Rail, that's never on time.
Documentation, then these may well lead to further prosecutions for driving without a license or driving without insurance. And in some circumstances, with very specific requirements,
Really?
under sections 165A and 165B, the police can seize vehicles that are being driven or have been driven without a license or insurance. However, it's important to understand that you are not under arrest just because the police has pulled your vehicle over. At least unless you fail to pull over, and then you may well be arrested. But you and your vehicle are being detained under section 163 and the police officer's power to stop a vehicle. So if you are not under arrest, but you are being detained and you're required to pull over, otherwise you are guilty of an offence, what else must you do after you've pulled your vehicle over to the side of the road? Well, as the law requires you to pull over when required to do so, and to provide the information when asked to do so, and it is a defence to do so within 7 days, and provided that you have or will comply with those requests, there is generally no additional obligation for you to turn off the engine, hand the keys to the driver, get out of the vehicle, and so on. And there have been cases, such as the example described in the blog post, which I will link below, written by a solicitor who brings claims against the police for alleged wrongdoings during such a stop. But again, as I often say on this channel, civil cooperation, including with the police, can often go a long way, but it is also important to remember that there are limits as to what you are required to do by law. And beyond that, simply refusing to cooperate with unreasonable requests does not necessarily mean that you are guilty of an offence, and may actually lead to an actionable claim against the police. For example, if you are physically dragged out of the vehicle because you refuse to get out of the vehicle, when the law didn't require you to do so. But again, every case is very fact-specific, and if there was simply one fact in any particular case that gave the officer reasonable grounds to lead to the arrest of the driver, then obviously his refusal to cooperate is going to be detrimental. But in many cases, the law can be very complex, and with the greatest respect to all of you guys watching, finding any specific defence or any specific requirement, what you are or are not required to do by law, else you commit an offence, can be very difficult. This is ultimately why I say you should always seek formal legal advice.
Smart move there, Barrister, and I will leave you. Hopefully next time we'll have a better connection for your information from the UK. And with that, we'll finish this final fight up and bring part 2 to a close for this day. As always, please do like, share, and subscribe. Get us to those goals of 5,000 views. So Boxing Extras will pay attention and start sending us items that we can send to you. And 1,000 subscribers, so Google, YouTube start sending us items that we can send to you as well. Coinbase information below. Since I already did in part 1, I won't do it again here in part 2. Just follow that if you wish to get the free crypto and Coinbase Earn lessons. Do we meet in the overnight, for part 2 of the Midnight in the Desert, Art Bell's absolute last appearance ever on radio. Please like, share, and subscribe, and we'll see each other in the overnight here on From Day One.